Hi, I'm Lana Shearer, a family law attorney and mediator in Elk Grove, California, and I'm here with Christine Faulkner for our next episode of Family Matters. If you joined us in our last episode, we talked about community property and separate property in California and how that's defined and what that means. And today we're going to talk about your estate plan and how community property and separate property is handled through the estate planning. Christine?
Yeah, thank you, Lana. So we talked a little bit last time about how when I'm creating a trust, this doesn't come up so much in a will-based plan because generally folks who have a will-based plan haven't accumulated a whole lot of property, but certainly it could apply there as well. But generally, you're not dealing with a piece of real estate. So when I'm dealing with a married couple and creating a trust-based plan, we do talk about property. We talk about the nature of property, whether it was acquired through, before marriage, how it's titled now. Because my firm, when I'm working with clients to create a trust, we will collect copies of their real estate deeds because we're creating new deeds for them to put the real estate into the trust. And that means that we're retitling that piece of real estate out of their names, jointly into their names as trustees of the trust, or if it's a separate piece of property, the individual's separate property. And how that is titled kind of depends on the discussion, how that goes in the meeting. As I said last time, I have very few clients who adamantly really want to keep separate properties separate once they get married, especially if it's been a long-term marriage. They tend to feel like no matter where it came from, it's all community. It may have already been retitled into their names in community or in joint tenancy. And so then we're just retitling it and putting it into the trust. And as I said, the trust itself indicates that the legal character is not changed from how that property is titled immediately preceding going into the trust, even though it'll look different, right? It'll be in their names as trustees of their trust, or it may be in one trustee's name as trustees of their joint trust. It still retains the legal character as it was immediately preceding going in. And so, as I said last time, every once in a while, I do have a client who says, this is really important to me that I keep this property separate. And so when we are titling it, sometimes I do have clients who say, I really don't want my spouse to have access to this account. We've maintained separate accounts before. We like to have that autonomy. Sometimes there is a trust issue. I find in many of my clients, they have the opposites attract. So one of them is really good with money and the other sometimes is not. And so they really do. It is important to them that they maintain autonomy in keeping their money separate so that they can take responsibility for those accounts on their own and their spouse can access it. And so when that happens, we will literally title the account in that owner's name alone as the trustee, meaning during, as long as they maintain capacity, they really do have access to it alone. The co-trustee, their spouse, it's not titled in their name. And so that's one way that we can give it the protection from probate if one of them were to die, but not allow the other spouse access. That's a true minority in most of the people that I work with. They really have already considered that property to, even if it is separate property, to be community property, and we just title it in both spouses' names as trustees of the trust. Now, when we talk about designing a plan for after death, after one of the spouses passes away, we do talk about, depending on the kind of plan that a client creates, Maybe everything that the two of them acquired together, both joint and separate, everything just goes to the survivor. That's one way you can design a plan. Another way you can design a plan is to create what's called AB trusts and to split the property. Back in the day, before we had this really high estate tax exemption, it was done to protect the exemption of the deceased spouse. Most of my clients don't fall in the uber wealthy category where they're literally needing to split assets now to preserve the exemption, because we have almost a $12 million exemption per person. But sometimes clients like to do that for asset protection. And so,
and what do you mean by asset protection? Is it asset protection like you want to send it just to one person and not have it go to other people, or what do you mean by asset protection?
That could be one way. So many times in blended families, clients will create this kind of planning to make sure that the kids from a prior marriage will receive that share of the assets. So, and we'll talk about blended families because it's a whole nother conversation, but this is a plan design that is favored many times by blended families because you have a lot of moving parts, right? You have the kids from the first marriage or prior marriages or prior relationships, and then you have the current union, and wanting to make sure that if you pass away first, that not everything is rolling over to your existing spouse, that you are preserving a portion of that for, that's set aside, that maybe can be accessed by the existing spouse as a trustee. Maybe the plan is designed in such a way that they cannot access it. You have a third trustee or a second trustee that's named to oversee that, and whatever is left in that trust is actually pointing to, or being distributed to the beneficiaries in the way that the deceased spouse chooses.
Okay.
So it's
and you
all
call
part
that
of
an AB trust. So it's like, that's how that vehicle to do that.
Yeah. And so the other thing is when you talk about asset protection, if you are creating that type of trust structure, you can create asset protection because it goes into an irrevocable trust, and there's a separate tax ID that is assigned. So it's not owned by the surviving spouse, it's owned by the trust. And there are some specific tax ramifications that come from that. But if there were to be any type of creditor issues for the surviving spouse, again, depending on how the trust is designed, the decedent's half of the assets, including their half of the community assets and any separate property assets, go into that AB, trust structure, the B trust. And that is protected from the surviving spouse's creditors. And so it's kind of a nifty way to kill a couple of birds with one stone. Not all of my clients like this kind of design because it's much more complex. But many have, I've noticed, especially this year, many have opted for this type of planning because it does give some creditor protection. So some unforeseen, if the survivor had to file bankruptcy, if they were, in a terrible auto accident and in litigation, somebody became a quadriplegic and they didn't have enough insurance and there was going to be an adverse damage award. Everything in their survivor's trust could be taken because it's owned by the survivor, but this creditor protected trust, that can be touched. And so
is that what you mean by irrevocable? If it's irrevocable, it provides some creditor protections, but if you have access and control over it, so irrevocable, then you don't have those protections.
Right. So the indicia of ownership versus having some strings attached to it, which there are in that B trust, it is also a separate tax entity, which means that the surviving spouse doesn't own it, the trust owns it, and that gives it some indicia of the surviving spouse may be the trustee. They may be able to have some control over how the assets are used and invested, or possibly not, depending on how the couple designs the plan. And so that's what I mean by asset protection. And so knowing what is the separate property of each spouse is really important because separate property of the deceased spouse goes into that B trust. The separate property of the surviving spouse goes into the survivor's trust. and then each of their half of the community property is split. And then this comes
Okay.
up once again when we talk about potentially creating what's called Dynasty Trust Planning for the children, usually for the kids.
Mhm.
You can actually create those same type of irrevocable trusts for the children. And so when I'm creating this planning, it kind of is asking the parents to have a really zoomed out approach in looking at, you know, what happens to the assets that they're leaving for their kids. And I know, that my kids are not married, they're in their 20s or early 20s. And so asking parents to imagine if they have kids that are not married, when you leave assets for your children outright, it goes basically into your kids' hands, it goes into their bank accounts. And then when they get married, if they do, those assets can be commingled with their new spouse. And so what happens then if their kids get divorced, the inheritance that you've left for your children could actually be partially lost in the divorce, especially if they're not really good at record keeping, which everybody going into a marriage is very lovey-dovey, right? Loving and generous.
Right.
And then when it comes time to the divorce, again, that record keeping can be not so great. And so when I'm talking to parents about designing a plan, I'm reminding them that, when your children marry, if you leave everything outright to your children, you need to be cognizant of the fact that depending on how they treat that money, if they're super good about keeping it in a separate account and never, ever commingling it, and they know not to do that, then great. But you have another way that you can actually create an irrevocable asset protection trust for your kids, which again has a separate tax ID. It's irrevocable. It is protected from their creditors. So not just their spouse during a divorce, but their own creditors. If they had a business and were being sued, if they, all sorts of creditor issues can come up, which I'm sure you can speak to. I imagine you see that. So yeah, that's another way that you can create asset protection and talk to people about more long-term, keeping your kids' assets separate from the inheritance that you give them.
So on the Dynasty Trust, does that just give them a certain amount, like per month or per year, or is it only for certain expenses? I mean, how does that, just briefly, how does that work?
So basically a trust is created for the child, and it doesn't come into existence. It's created in the plan, but it doesn't come into existence until both parents have passed away. Then the trust is created with a separate tax ID. Ordinarily, the child will eventually be able to be a co-trustee of that trust at a certain age, depending on the age that the parents have chosen, especially if they have very young kids. And then eventually the trust language itself will say, okay, at a certain age, my child can be the trustee of their own trust. And the idea is that they have the ability to control the assets. They have the choice of how to use the assets within the trust, but the trust does have a separate tax ID. It is like a separate legal entity, such as a business like an LLC or a corporation. And the idea is that the assets will always be kept separate within that separate trust, being controlled by the child. If they wanted to, say, purchase a piece of real estate to be a rental property, they would purchase and title that property in the name of the trust. They're the controller. The trustee is the one who makes decisions about it. The rental income would come into that trust. But the child, the trustee, would have the ability to use the assets as they would like to use it. But it is never commingled with the spouse. And so so imagine they have a Morgan Stanley account, and that investment account is going to be held in the name of the trust. The investment proceeds are going to be held, the gains are going to come back to the trust. And then, but of course, the trustee of the trust, the child, can continue investing, but also use those assets for their own benefit. They can write themselves checks, they can take money out, but they're not going to ever commingle it with their spouse. And so it's always going to remain a separate asset.
Oh, that's a great way to maintain something separate. Keep it separately titled and don't commingle it at all. No, that's very interesting.
Yeah.
Well, thank you. I learned a lot about that. I appreciate that.
Yeah, and I think that COVID really has been an eye-opening experience for many people. And talking to many of my clients this past year about asset protection, I've seen an uptick in people really wanting that kind of planning in their plan for both their spouse and for their children. I don't know if
Right.
it has anything to do with COVID or not, but yeah, it's a really valuable way to make sure that you are able to keep separate properties separate, and also make sure that it is protected from creditors, including, spouses. And I do talk to people about the fact that spouses in California can actually be creditors from the perspective of,
Hmm.
if you ever get a divorce or your children ever get a divorce, they
Right.
could be fighting for money that you've left for them. So think about how that feels and how you'd like that to play out for your kids, even if they're not yet married.
Right. Absolutely. Yeah. Long-term planning. That's important. Planning for all the unknowns. Well, thank you. That was very educational. I appreciate that. And lots of interesting, yeah, thought-provoking topics. Lots to talk about in our future segments for
Yeah.
sure.
Yeah, so we will be doing another episode on blended families, because that in and of itself is a really complicated situation. So we'll talk about maybe in one or two more videos about that. So thanks for tuning in, and we'll see you next
Absolutely.
time.
All right. Thank you.
Thanks.